Hello everyone, this is your host Urvashi Chauhan. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with an important update where the Supreme Court today issued notices for initiating contempt proceedings against government officials for the rampant felling of trees in Delhi's Ridge Forest area in violation of its previous orders. The court has also ordered the maintenance of status quo in the region. Let me tell you, Delhi Development Authority's previous applications seeking permission to fell or translocate 1,051 trees was rejected by the top court in March. However, it is the contention of the petitioners that during the hearing of those applications, the DDA failed to inform the court that the felling had already taken place even before the court could pass any orders on such applications. The petitioners also state that the ridge, which is the only forest region left in the national capital of Delhi, has been subjected to illegal felling to construct 10.5 kilometers long approach roads from the main Chhatarpur Road to Sark University and other establishments. The bench of Justices Abhay S. Oak and Ujjal Bhuyan today issued contempt notices against Vice Chairman of Delhi Development Authorities, the Director General of Central Public Works Department, the Director General of Forest, and the Principal Chief Conservator of Forest, Delhi. The alleged contemners have been ordered to be physically present before the court on the next hearing. A writ petition has been filed in the Supreme Court seeking directions to the Election Commission of India to initiate appropriate action against hate speeches being delivered by political campaigners, especially those on behalf of the Bharatiya Janata Party for the 2024 general elections. The petition seeks directions to the ECI to initiate an investigation into the hate speeches allegedly given by Prime Minister Narendra Modi and Union Minister Anurag Thakur. Filed by an ex-IS officer and a former IIM dean, the petition cites speeches given by the Prime Minister on 21st April and by the Union Minister of Information and Broadcasting and Youth Affairs and Sports, Anurag Singh Thakur, on 27th April. It is alleged that the Election Commission of India has failed to undertake decisive action, although repeated efforts have been made to notify it and prompt it of its obligatory responsibilities. Former Supreme Court Judge Justice Madan B. Lokar, former High Court Chief Justice A.P. Shah and veteran journalist N. Ram have invited Prime Minister Narendra Modi and Congress leader Rahul Gandhi to a public debate on the Lok Sabha general election 2024. The invitation states that members of the public have heard only allegations and challenges from either side and have not heard any meaningful response, saying that today's digital world has great propensity for misinformation, misrepresentation, and manipulation. They underscored the importance of making the public well educated about all aspects so that they can make an informed choice at the elections. They expressed the belief that citizens would hugely benefit by hearing from the political leaders through a non-partisan and non-commercial platform. The invitation letter was shared by journalist N. Ram on his X handle. In the next update, the Supreme Court has observed that there is hardly any compliance of the state of Maharashtra with the recommendations regarding police reforms made by Justice Sri Krishna Commission in the report relating to the 1993 Bombay riots. The commission was constituted by the state in the year 1993 to look into the causes of the fearsome riots that occurred in Mumbai in December 1992 and January 1993. This occurred after the demolition of the Babri Masjid. The recommendations included strict standards of physical fitness for police officers, improvement in their work conditions, and proper housing facilities. Regarding this, the court in its present order has observed that the total strength of the police force in Maharashtra is 230,588. However, residential accommodations have been provided to less than 1/4 of the police personnel. In view of this, the court has directed the Secretary of Home Department of State of Maharashtra as well as the Director General of Police to look into the implementation of the recommendations pertaining to the police force. These two officers are required to hold meetings with the other stakeholders. The bench of Justices Abhay S. Oak and Ujjal Bhuyan was hearing an application filed in the matter where the court had in the year 2022 passed a slew of directions regarding implementation of the Commission's recommendations. The Punjab and Haryana High Court has sought comprehensive affidavits from Punjab government on details of songs that have been recommended for ban or banned for promoting glorification of weapons and violence. The Punjab government in 2022 had banned use and display of firearms in public places and on social media. And accordingly, officers were instructed to conduct surprise visit in the areas falling under their respective jurisdiction. Earlier, the High Court had taken strong objection to the widespread use of firearms in public functions and the use of licensed guns to commit crimes in Punjab despite the ban. The court had directed the Director General of Police to file his own affidavit pertaining to the details on guidelines on issuing arm licenses and action taken to implement the state's order. However, in the present proceeding, the court found that the state failed to file a comprehensive affidavit. So now the court has directed the DGP to file another comprehensive affidavit on varied information, including who are the anti-social elements and what is the basis for determining anti-social elements. The court has also sought information regarding ban on songs promoting glorification of weapons and violence, and also the procedure adopted to achieve the same, specifically taking into consideration Article 19 of the Constitution of India. The matter is listed for 13th May for further consideration. Stay tuned. A single judge bench of the Madras High Court comprising Justice L. Victoria Gowri, while deciding a writ petition, has held that petitioners' qualifications should not be a barrier to compassionate appointment. Compassionate appointment, let me tell you, is a provision in employment regulations where a job is provided to a family member of a deceased employee as a gesture of compassion and support. This typically occurs when the employee dies while in service and the appointment is offered to their spouse, children, or dependent relatives as a means of providing financial stability and support during a difficult time. The father of the petitioner in this case worked as a cook at a welfare boys' hostel in Chennamar when he died in July 2021. His son, the petitioner, being one of the surviving family members, made 2 applications seeking compassionate appointment. However, these applications were not considered. Hence, he filed a writ petition seeking to direct the Commissioner Adi Dravidar Welfare Commission to consider him for compassionate appointment on merit. The commissioner, or the respondent here, contended that the petitioner was overqualified for the available positions of cook and watchman. The respondents further argued that when suitable positions arise that match the petitioner's qualifications, then his case would be considered. The court has now observed that the petitioner's qualifications should not be a barrier to compassionate appointment and has directed the respondents to consider the representations and appointment of the petitioner and appoint him to a suitable post in terms of seniority list maintained by the Welfare Department and District Collectorate. The Allahabad High Court has held that a person who follows Islam cannot demand rights like those in a live-in relationship, especially when they already have a spouse. A bench of Justice A.R. Masoodi and Justice Ajay Kumar Srivastava said so while refusing any relief in a plea for FIR quashing and protection filed by a Hindu girl and her Muslim live-in partner. They sought legitimization of their relationship, although the man is already married and has a child. Also before the court, the man said that he had divorced his wife, but it was found that he had recently filed a similar petition where he stated that his legally wedded wife was suffering from ailments due to which she had no objection to the relationship of both the petitioners. When the court called for a report from the concerned police station regarding his wife, it was found that the legally wedded wife was residing with her in-laws in Bombay with her 5-year-old daughter. So the court stated that the religious tenets to which the man belongs do not permit live-in relationships during the subsisting marriage. And lastly, let me tell you, senior advocate Kapil Sibal has filed a nomination to contest for the post of President of Supreme Court Bar Association for 2024-25 term. The SCBA elections are scheduled to take place on 16th May. Sibal was previously elected as the SCBA president 3 times. The last instance was 23 years ago in 2001. The incumbent SCBA president is senior advocate Dr. Adish C. Agarwala. Today was the last date for filing nominations. To recall, last week, the Supreme Court passed an order for implementation of minimum 1/3 women's reservation in the posts of Executive Committee of the Supreme Court Bar Association. The SCBA Executive Committee objected to this order, terming it as an interference with the independence of the bar. Later, the court clarified that women's reservation will be on experimental basis. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.